You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 133. What is the Patent Office Deferred Subject Matter Eligibility Response Pilot Program? Exciting stuff. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. Let's dive into the subject. The Patent Office is always trying out different kinds of pilot programs to streamline procedures and let you do certain things that aren't necessarily part of the normal rules for getting your patent examined. I talked about several of these before. There's a pilot program to get another bite at the apple during examination without paying extra fees. There's a pilot program about getting your application bumped to the front of the line if it's COVID-19 related. There are a few others too. There's one that was recently announced called the Deferred Subject Matter Eligibility Response Pilot Program. So what's it all about? And to understand the problem they're trying to solve, we have to go all the way back to the beginning of the requirements to get a patent. Your invention has to be new, useful, and non-obvious. I've talked about that a lot before. But it also has to be subject matter eligible. Certain things like mathematical formulas, scientific principles, and abstract ideas are not patent eligible. You cannot get a patent on these, even if your mathematical formula is new, useful, and non-obvious. It's more like a product of nature. It already existed. It's an abstract idea. One of the gray areas are business methods and whether business methods are eligible to get a patent. Let's say that you were Netflix back in the day. You were the first to have a subscription model to mail DVDs out as rentals. No one ever did it before. You invented this type of subscription model for DVDs. It's that kind of stuff where it's a gray zone. Also, software patents are in a gray zone too. That's a big matter that a lot of people are trying to deal with. If it's something where people can do it, but you're just saying do it on a computer with software, oftentimes it's not going to be eligible. I've talked about this case before, but there's a case in 2014 called Alice versus CLS Bank, where there were claims for software doing financial transactions. And the Supreme Court said those claims were for an abstract idea, but the court made it difficult because they said although those claims weren't patent eligible, they're not saying that all software claims were ineligible, just the ones that were written in that case. Then there were also a series of cases called Bilski, Mayo, Myriad, and then the Patent Office has come out with memos about about how they want to analyze it. And there are federal circuit cases like Berkmeyer and Enfish. So patent attorneys have been trying for the past several years to figure out how to write claims to get software patented. And the Patent Office keeps coming up with new guidelines. They're changing all the time how to determine what counts as being subject matter eligible. And they have a flowchart, and they have examples, and then the courts make a ruling on a new case that throws a wrench into everything, and it looks like cases contradict each other. So it's really hard to know whether your business method or a software patent will even be eligible. There can be other types of things that are ineligible, but it's usually software or business methods that we're dealing with. Because if it's a physical object that you've created, generally that's not an issue on whether it's eligible or not. If you want to see a table of cases and flowcharts, you can find them on the Patent Office website, and you can get to it. Just do a Google search for USPTO patent eligibility examples and flowchart. The latest I see, and I'm recording this in May 2022, is from 2019 for examples on their website. And there's also a PowerPoint presentation you can see from the Patent Office from February 2022 called Subject Matter Eligibility, USPTO Guidance and Policy, and it's 37 pages long. Now, if you look at the flowchart, the first step, which is called step 1, is called the statutory categories. The question is the claim to a process, machine, manufacture, or composition of matter? If the answer is no, then it's not patentable. It's not eligible to be patented at all. That's a simple case. If the answer is yes, you have to ask the next question, which is called step 2A, which is called the judicial exception cases. Is the claim directed to a law of nature, a natural phenomenon, or an abstract idea? If the answer is no, that's also usually an easy answer, because if it's not directed towards those, then it's eligible. If the answer is yes, then we have to go to part 2A, which is, does the claim recite additional elements that amount to significantly more than the judicial exception? If the answer is yes, then it's eligible. If you said no, then it's not eligible. And if you said, what the hell does that even mean? What does significantly more than the judicial exception mean? Then you're like every other patent attorney trying to figure out what's eligible and what's not eligible. And really, you just have to look at the cases where the patent office or the courts said yes or no to certain things that were, quote, significantly more than the judicial exception. And you can come up with many factors that push the answer one way or the other. And that's where those examples are helpful on the patent office website. One example given is software for facial detection that was found patent eligible. Recently, Airbnb received a software patent for automated determination of booking availability for accommodation listings. Coinbase received a patent for allowing Bitcoin to be sent to an email address with no miner's fee. DoorDash received one for an automated vehicle for autonomous last-mile deliveries. These are just the titles, so you really have to look at how the claims were written to see if they were allowed. But, and this is a big but, any new case that comes out can change this analysis, and maybe what was allowed last year wouldn't be allowed this year. Maybe what was not allowed last year would be allowed this year. It's a big mess. So, that brings us to the topic of the episode, which is, what is the Deferred Subject Matter Eligibility Response Pilot Program? When you get a rejection from the patent office, the rejection can be for a lot of things. It might be subject matter ineligible, but even if it's eligible, maybe you can't get a patent on it because it's not new or it's obvious. So if you get a rejection for ineligibility and obvious, you have to respond to all of those rejections in the next response that you do. What if you spend all this time arguing why the patent examiner was wrong to reject your application based on subject matter eligibility? You're fighting about eligibility, and you even convince the examiner after spending lots of time fighting about it, and your application still gets rejected because it's obvious. Well, then you spend a whole lot of time and money for no reason. And that's where the Deferred Subject Matter Eligibility Response Pilot Program comes in. What this does is that you are allowed to defer responding to the eligibility rejection at all. And you can just focus on whether it's new and non-obvious. Because if you can't convince the examiner of that, then it's a moot point on whether it's going to be subject matter eligible. So you can defer the eligibility question until you get a final rejection. The way that this works is if the patent office rejects your application on subject matter eligibility and other grounds, the examiner will invite the applicant to be part of the pilot program. And then the applicant fills out a form to be part of the pilot program where they don't have to respond to the eligibility rejection. And who knows, by the time you get a final rejection, which is usually the second rejection, maybe the rules on subject matter eligibility will be different. So you'll have an easier time getting an allowance. The point is, the patent office is allowing the application to defer the really hard aspect of eligibility to a later time. There are some other rules about who can be part of the program, but that's the gist of it. Deferring any arguments you make for eligibility for a later time and focusing the initial response on what should be a more clear-cut reason for rejection, which is usually a rejection in terms of lack of novelty or being obvious. So if you get a rejection for lack of subject matter eligibility, discuss that with your patent attorney, and maybe you want to defer responding to that part of the rejection. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamantpatentlaw.com. That's DIAMENT patentlaw.com, or call me at 424-281-0162. I'm Adam Diamant, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. For more information and help with your own intellectual property needs, contact Adam Diamant directly by going to diamantpatentlaw.com. That's DIAMENT patentlaw.com. Or click the show links to connect by phone, text, or social media. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.